The British Court of Appeal has ruled that the United Kingdom's government's plan to send asylum seekers to Rwanda was unlawful, as the African nation could not be considered a safe third country. Three appellate judges overturned a High Court ruling that previously said the East African nation could be considered a safe third country for migrants to be sent to. Announcing the ruling, Lord Chief Justice Lord Barnett said he does not accept that migrants will be at risk of removal to their home countries from Rwanda, but it is not a safe place for them to be housed in while their asylum claims are processed. The Rwandan government has, however, taken issue with the ruling, calling the nation one of the safest countries in the world, having been recognized by the UNHCR and other international institutions for its exemplary treatment of refugees.
The result is that the High Court's decision that Rwanda was a safe third country is reversed, and that unless and until the deficiencies in its asylum processes are corrected, removal of asylum seekers to Rwanda will be unlawful. Finally, I should make clear that our decision implies no view whatever about the political merits or otherwise of the Rwanda policy. Those decisions were made in accordance with arrangements between the two governments announced on the 14th of April 2022 and contained in a memorandum of understanding and a number of diplomatic notes verbal. They comprised the Rwanda Agreement. On the basis of the assurances from the Rwandan government contained in the terms of the Rwanda Agreement, its terms more broadly, monitoring arrangements in place and other inquiries carried out by the United Kingdom government, Rwanda was treated as a safe third country under the relevant provisions of the immigration rules. This is the Rwanda policy. The appellants and other claimants brought proceedings in the High Court challenging both the lawfulness of the Rwanda policy generally, referred to as the generic challenge, and the government's decisions specifically to remove each of them to Rwanda. Removals did not go ahead pending the outcome of these proceedings. The central issue before the High Court and before us was whether the asylum system in Rwanda was capable of delivering reliable outcomes. The appellant's case is that there are substantial grounds for believing that there is a real risk that any person sent to Rwanda will be removed to their home country when in fact they have a good claim for asylum.